He went from facing 189 years to only serving 27 months and not being in this RICO when he's in like all these overt acts.
Were you aware that in open court?
Objection, Your Honor, as to whether or not I'd ask that the witness be required to give a foundation for anything done while he wasn't in here considering the rule of sequestration.
About him. Were you aware that in open court, DA Love wanted to remind your attorney
Objection,
that you're
Your
on 20
Honor,
years
that is
probation?
not relevant and that is improper, and Mr. Sharp knows that.
Sustained.
I mean, she did do that. She was trying to remind him, you're out on 20 years probation.
An objection that the state has regarding the last line of questioning by Mr. Sharp when the state objected based on the beginning of his question. And Mr. Sharp asked the question that he did. Are you aware that the district attorney told your attorney that you face 20 years of probation? This is not the first such kind of question regarding something that is improper that has come up. And I would ask the court to remind counsel that those types of, that's not an appropriate line of questioning. It's not a relevant line of questioning. And it's just an attempt to essentially cast aspersions on opposing counsel. And I don't think that that is proper, at least not the question that he asked.
Your Honor, I wasn't casting aspersions on opposing counsel. I was casting aspersions on what opposing counsel did. I couldn't
Same
believe
thing, Your Honor.
Can I finish? I couldn't believe it when I was in court the other day and a DA is sitting there talking to, in open court, to the attorney of a witness and is openly saying, I just want to remind him he's on probation for 20 years. I mean it. And my thing is, she knows why she said it.
Your Honor.
That message was to be relayed to Demekion Gar, to Quindarius Zachary. That's the only reason it would be said in open court. And I assume that Mr. Scheib, in his short tenure as attorney for Mr. Zachary, conveyed that message because that message was made loud and clear in open court. Mr. Scheib was not the one that needs to testify, according to the state. Mr. Scheib's not the one on probation. Mr. Zachary is. So yes, when the state says to about a state's witness to their attorney in open court, I just want to remind him he's on probation for 20 years, and I'll charge him with perjury and will revoke his probation. Whatever was said, I would rely on the transcript. Yeah, I assume that message has been relayed to the witness, and I do believe it was intimidation. I'm not going to sit here and say it's witness intimidation and all that. I'm not saying that, Judge. What I'm saying is intimidation in the colloquial layman's term sense. It was a message that was sent, and I wanted to see if he received the message because that is relevant to his bias and motive in testifying.
Your Honor, Mr. Sharp knows that, number one, all of the things that he's representing as being said weren't said, and he still knows that that was an improper question to place before this witness. And to the extent that any attorney is asked something outside the presence of the witness, to ask the witness, was he aware of something that was said outside of his presence? Mr. Sharp has no good faith basis for asking the witness a question. It is not relevant whether or not the witness's attorney, some other person, was told that his client should not commit perjury. And I don't think all of what Mr. Sharp said was false assertions, false representations, misleading representations before the jury under 403.
Note, Your Honor, that not one time when Mr. Zachary was on the stand did I claim that Miss Love intimidated him. I never used the word intimidate in front of the jury. I'm talking about. What I said was, are you aware that Miss Love talked about your, I can't quote directly, but talked about you're still on 20 years probation, which was said. I don't even independently know how many years probation is. The only reason I know is because Miss Love said it in open court. So everything was factual. And, I think it's relevant when a DA is saying, and I'm not trying to pick a fight with Miss Love. If people are difficult witnesses, we all deal with difficult witnesses in different ways. So I'm not even trying to judge what she said or how she said it. All I'm saying is it was said. And I wanted to know if he got that message, because that message was clearly intended for him. It wasn't intended for Dennis Scheib.
Well, I'm not sure that's true because at the time, I don't think they had yet negotiated the terms of the immunity deal. But Ms. Love, your objection was sustained. So that's really all there is to it.
Judge is like, all right, it's sustained. Who cares? Let's move on. But I'm telling you, this judge don't give a fuck sometimes.
I think the main thing to it is that Mr. Sharp he talked.
Ms. Love, I'm going to take a bathroom break, okay? I haven't had one for the last couple of times that everybody else has.